Thanks very much. You're all very welcome. Thank you for doing the graveyard shift with me. I much appreciate it. You and Alicia Keys are very welcome in the room. I can actually feel Alicia, not just hear her because the vibrations. But apparently this is not the worst room, that there's other rooms are worse. As I've already said, my name is Valerie Lyons. I'm sure you can hear from my accent that I'm not a local. So I'm from Ireland. I hail from Dublin. I'm a recovering CISO. I was a CISO for many years, 15 years in KBC Bank in Dublin. And so after that, I moved into privacy a decade ago. So I've spent the last 10 years working and studying privacy. My PhD is in privacy and trust. So ethics is kind of my place of comfort. I have something to just to note that I did come over from Dublin with a large number of suitcases on Sunday, and I packed what I thought was everything, but I didn't pack my glasses, so I cannot read the screen. So I'm going to be hugging this podium like a lost child, and every now and then I will point to the screen, but I actually can't read it. So just bear that in mind if you see the pointer in the wrong place. Before we begin, just a couple of things that we need to kind of clarify is what this session is about. So if you're expecting me to go through definitions of AI systems, we're not going to be going into that level of detail. We'd need a whole new session for that. What this is about is we have in Europe a piece of legislation called GDPR. And now we have a new piece of legislation that's going to regulate how AI works within a European context. And it's about the integration of those two pieces of every now and then my mic goes. Those two pieces of legislation, it's about how they integrate with each other, or as is the case most often, how they don't integrate. The way I've structured the slides is so that you have a lot you can take with you, that you can take home with you. So when it comes to the solutions, to the challenges that I present, you'll be able to take a lot of those solutions home with you, but I'm not going to go through each of those solutions. I put them in the slides so that you could have something that you could take away in terms of audience takeaways. So that's why they're in the slides. And finally, just to say, this is my top 10. This is not the top 10. There are so many challenges in this space. When I curated these top 10, I almost felt like it was the Titanic, and I was trying to find the women and children and put them in the lifeboats, because it was a really difficult decision to make as to which ones I would include. So these are what I believe are the top 10, but there are plenty more. Take it from me. Okay, so we shall begin. Apparently this is sticky. So disclaimer, we'll pass by, the disclaimers. This is my disclaimer, okay? You say tomato, I say tomato. There's a difference in the languages that we use. So I use words like personal data, data subject, and data protection. Whereas here in the US, you use words like personally identifiable information, individuals and consumers, and privacy. And those words, we've come to kind of use them interchangeably, but they actually mean different things in both of those different places. So I'm going to move with the US context, and I'm going to stick with that particular type of language. So let's have a little bit of a background. Anybody want to hazard a guess as to how long AI has been around? Throw me a number. 60 years. Well, it's in the 50s. That they say. So a little bit more in the 50s. Turing is the one who's really considered the father, and the term became known in the 60s. But the big difference is the time to reach 100 million users. So we see in 2006, Google Translate took 78 months to reach 100 million users. And then we have ChatGPT, 2 months to reach 100 million users. And I know everybody in this room is saying, I was one of those 100 million users. I certainly was. The big difference is that time to reach 100 million users. And the other thing that has to be said, and it is about regulation. Regulation doesn't exist in a vacuum. It exists And the AI Act, you have to think about how it's constructed and why it was created. It exists because organizations traditionally didn't do right by the data. They didn't do right by the data subjects. So that's why it exists. So when we're talking about the regulation and the AI Act and GDPR, just understand that it's trying to address issues of the past and anticipate issues in the future. So these are the top 10 that we'll be going through. It's a whistle-stop tour. Pretty much I'm going to be talking for about 40 minutes. We're going to try and leave some time for questions. So it is a whistle-stop tour. Move with me on the tour. So there are some that are my favorites. I don't know if anybody has favorites in terms of challenges. I don't think it's the right word to use. But inferential data, number 6 there, I think is the most interesting of the challenges and the one that's going to cause the most problems, I personally believe. The legal basis for processing. Have we any lawyers in the room? Anyone want to admit they're a lawyer? Or an attorney? Sorry to use your language. An attorney? No, we've none. Okay, we can use English then. Otherwise we have to speak in attorney language. We're going to see this guy come up a couple of times as we go through the presentation. What this guy means is there are no answers. We actually don't have a solution to the problem, and there's plenty of this guy coming up. It's not that we don't know what the answers are. We actually are waiting on the answers. We're waiting on the end of inquiries. We're waiting on cases. We're waiting on interpretation, just as we did with GDPR. So we'll have the answers absolute when we get those. But right now, we're we're operating in a vacuum without those answers. So the first challenge is the approaches and terminology. The approaches are somewhat similar, but they're also different. And the differences are where we're going to have some complications. So GDPR, I'm assuming that everybody is kind of GDPR aware at this stage. GDPR relates to the processing of data. So it's very much about personal data versus special category data. But it's always, the risk is always based on the individual. So GDPR is focused on the individual. The AI Act is focused on systems. The individual is not involved at all in the AI Act. In fact, it carves it out and it says, look to GDPR for data subject rights if we want to protect the individual. So the two have taken a completely different approach. Penalties of up to 7 million, or 7% or 35 million for the most significant infringements of the AI Act, and penalties of up to 4% or 20 million for infringements of GDPR. Now the question that has only recently been answered in terms of the challenge between these two is, if an AI system has a breach and the breach involves personal data, do we get hit twice? Do we have two sets of penalties? And the ICO, that's the Information Commissioner's Office in the UK, has confirmed, yes, you do. So, you know, these are significant fines. Just on those fines, like, to be fair, does everybody, you know, here in the US recognize that the Data Protection Commissioner in Ireland has fined large tech companies enormous amounts of money? So, you know, we hear that all the time. We've not got one penny. So I'm not too sure how much these fines are actually going to affect the progress of how we process data, but it's there. So that's the fines. We also have two interesting things, which is GDPR doesn't allow you to process special category data unless you have sort of a reason that's included in what's called Article 9. And now we have a number of new uses of special category data that are allowed by the AI Act. So for instance, if you want to use special category data, one of 8 categories, if you want to use that for, say, detecting and correcting bias or improving cybersecurity controls, you can now use it. So that's going to require an update into GDPR. Those Article 9 allowable uses are not the same in both those acts, so we're going to have a change made. This is how the AI Act approaches risk. So bearing in mind, GDPR approaches risk in an entirely different way. It identifies 4 different kinds of systems: unacceptable risk, high risk, limited risk, and minimal risk. So they're the 4 different categorizations. The 2 we're particularly interested in is high risk and limited risk. Obviously, because they're the ones we're allowed to do, and they're the ones who have obligations on us. So the obligations for transparency at limited risk level also rise up. Transparency also applies at high risk level, but we also have something else to do in the high risk level, which is a conformity assessment. And many people are making the mistake of believing that a conformity assessment is the same as a data protection impact assessment in GDPR. It's not. It's not the same at all. It's about compliance to the AI regulation and showing compliance to the AI regulation. It's not a data protection impact assessment, nor is it an AI impact assessment, and we'll be talking about that later on. What I think, and I want to just point, and don't ask me to point at this because I won't be able to find it. I want to direct your attention to limited risk. You'll see the last one in limited risk there is deepfake. I don't know who thought that that was a limited risk. You know, we're hearing about disinformation and misinformation all week at this conference. I nearly called it a concert because of what's happening downstairs. So I don't necessarily agree with the risk levels, that they have limited risk there, but it is in the Act, and that's what their determination is. GDPR, on the other hand, takes a completely different approach. GDPR says the risk is the risk to the data subject, to the individual. And so it highlights that there are criteria. The European Data Protection Board came out with a set of criteria and said, if any of these criteria apply, the risk is elevated to the data subject and you need to do a data protection impact assessment. In other words, we're looking at the risk to the data subject, to the individual, and not the risk to the systems that they're using. And so this is going to be a real complicated area. How do I know when to do a risk assessment with AI? One of the things in the center, you'll see there, is use of new or innovative solutions. So I know if I'm using a new or innovative solution, which is AI, that I must do a data protection impact assessment. So we're all in agreement. Well, in 5 years' time, AI is not going to be new or innovative. It's just going to be the normal, isn't it? So how does it apply then? And I think we're going to need some more clarification on what that looks like. The Brussels effect. This is, again, another approach. It's the approach that the EU regulation love. They love to make the regulation that they are producing at the moment applicable globally. And so whilst we love it, everybody else hates it. But essentially, if you market AI systems into Europe at all, you must comply with the AI Act. In GDPR, if you direct or target data subjects in Europe, you need to comply with GDPR. But they're still very different in terms of how do other organizations who maybe, excuse me, target a market but not data subjects, do they have to comply with both? And the answer is yes, they do. Second challenge is accountability and governance. Accountability is in both the AI Act and GDPR, and it means exactly the same. So it's not a challenge by virtue of the fact that they are the same. We have accountability requirements, and all accountability means is that if a data protection commissioner or supervisory authority is sitting across from you and asks you explain how you came up with that decision, you need to have a set of documentation available to you to be able to say, this is what we did, this is how we came up with that. That's really what accountability means. The Data Protection Commissioner in Ireland has produced this as the definition for accountability, which pretty much backs up what I just said. The problem with accountability is that the overall problem is relying on organizations to assess the risks they create is like asking the fox to assess the dangers to those in the hen house. And that essentially is the problem with accountability, particularly with AI, is we're asking organizations to assess the risks that they create. How to address this challenge? Well, we have a number of different things, but one of the most important is that the European Data Protection Supervisor has noted that for accountability, the best thing we can do is to look to standards. And they particularly call out ISO and NIST. And I think the reason they called out those two is because both have got cybersecurity, privacy, and an AI governance and risk management components. So I think that's why they called out those two. The next one I'd like to highlight there is including human rights, ethics, fairness in GDPR's impact assessments. If anybody's ever tried to do that, a data protection impact assessment, and looked for the ethical element, they would struggle to find the ethical element in any templates. So for anybody who is in that space, who's trying to do that at the moment, there's a great paper from a scholar called Alessandro Montelero. He does a lot of work for IAPP. He wrote it in 2018, and it's called A Blueprint for AI. And in it, what he does is he takes human rights ethical impact assessments, and he combines them with data protection impact assessments to form a data protection ethical impact assessment. So it's the best template that I can find, and so it's a great paper to read as well. Okay, the third challenge, data subject rights. We love them in Europe, and I understand that in the US they hate them. We believe that they're powerful consumer rights that we essentially have, and they really are powerful, but unfortunately they create a lot of problems for the AI regulation. To try and explain, because in the context of maybe not understanding what it feels like to have these rights, so if you're from a jurisdiction that doesn't have these rights, to try to get a sense of what it looks like, I think the best way for me to do that is just to give you this example. This is my little box of secrets. I'd like you to put into my little box of secrets here to imagine this to be an AI tool that you use, that you have used, and then we can talk about that. Now, I'd say if I did a hands around the room, 75% of you are probably thinking about the same AI tool, but we'll move with it anyway. So let's think about it. What goes into the box? Yeah? So what is the source of it? And this is a big problem, because I was at one of the conference sessions I was at. They spoke about when data is manifestly made public, how we can use that data, using AI data scraping. That is the case in the US, but it's not the case in the EU. Just because something's manifestly made public doesn't mean you can use it for any purpose you wish. You need to have a legal basis in Article 6 to process data. So the source of the data has to be a legal source. And we're going to talk about this. This is one of the reasons Garant shut down OpenAI. Am I informed? Am I told that my data has been used to train a model? Can I object or challenge the data? Can I say that I don't want that data? Can I take my consent away from that? Is it legal or compliant? Does it have a legal basis in GDPR's Article 6, which we'll be talking about, that legal basis? Inside the box, something happens. Okay, there's processing that occurs inside the box. Again, I have the right under the AI Act to know what exactly is that processing. Can I object to it? Can I challenge it? Is it legal or compliant? Does it have a legal element in Article 6 of GDPR? And most importantly, is it profiling or predicting? Because if it is, then we need to think about something else as well, which we're going to go into later on. And what comes out of the box? Now let's just think about generative AI. What comes out of the box? Did we ask ChatGPT way back when to tell us about our biographies? You know, many of us were dead in our biographies. There was a lot of problems with accuracy. So what data comes out of the box? Back to those data subject rights. Am I informed that that data has been predicted or that I have been profiled? Can I request it to be deleted? It's almost impossible to delete data from once it's gone into the training set. Can I get access to the data? Can I make a subject access request without compromising other people's privacy? Unlikely. And does it have a legal basis? So there's our data subject rights. And that's ChatGPT. And the answer is really no to a lot of these things. So what can we do in the meantime? In the meantime, we can publish privacy notices that are what are called aware, so that they're activity and processing aware, that we give more information than we traditionally did in the past. We need to establish a legal basis. We're going to talk about that. The legal basis is a really complicated one for AI. Most likely we're going to have to go for what's called legitimate interest. And it needs to be compliant. Again, inside the box, the recommendations seem to be that we need to do a DPIA. with including an ethical impact assessment and obviously for high-risk system, a conformity assessment. And then for what data comes out of the box, we're being recommended to use things like differential privacy to update our subject access request processes. These sound very, very straightforward, but these are not easy things to implement. So you can see the complications there that we have. Data minimization and purpose limitation principles in GDPR. And they're very integrated. I need to limit the purpose of data because I can only use data for the purpose, Article 6. And that results in having minimum data collected in order to meet that purpose. So if we look, it's gone sticky. The AI Act explicitly provides that GDPR principles apply to training, validation, and testing data sets. So Garant, as we might well remember, didn't in fact have a legal basis to process the data in Europe. It did in the US when it developed its training set. Scholars, almost every paper that you read coming out in 2023 and 2024 says it's nearly impossible to perform any meaningful limitation or data minimization for data used to train general AI systems. And the ICO, the Information Commissioner Office in the UK, has said that developers who rely on very broad purposes are likely to have difficulties. Now, I don't really know what difficulties means, but one would suspect fines is what it means. The ICO have conducted a number of what are called call for evidence. So they encourage experts to submit in their call for evidence, and then they pull it together and they produce a report. So the first one, the Generative AI Call for Evidence for Purpose Limitation, in it they outline, so if you're interested in that space, in that report, they outline a solution which is looking for exceptions. So there's a number of exceptions in GDPR, and you can look to that paper to see what exceptions you can leverage to avoid the limitations set by the purpose limitation. One of the things this is just a list of things you can do to address this challenge is if using AI to make solely automated decisions about people with legal or significant effects, you can also consider, and you have to consider for high-risk systems, that a human must be involved. They call it a human in the loop. Again, we don't know exactly how this is going to work, but it mandates that a human in the loop be involved. So the legal basis. Has everybody come across a legal basis under GDPR? Do they understand what legal basis? Okay, that's great. Article 6, the legal basis under GDPR. This is the series of legal bases really that we can use. There's other legal bases like vital interest. We're never going to be able to use them. So this is the list that we can use or that have possibilities. Consent is not a possibility because really I'm not going to be able to take my consent away. So I have to be able to remove my consent easily. I won't be able to do that. Consent has to be fully informed. That's also going to be a problem when we're developing training sets about fully informing. So it's a complicated area, and consent is to be avoided. Contractual obligation, well, we think we can use contractual obligation if there was a contract in place before we introduce the AI. So we think that that's a possibility. Legal obligation, well, there's no legal obligation yet to use an AI system, so we can't use that until we have such a legal obligation. And then there's legitimate interest. Now, legitimate interest is one that organizations tend to rely on after they've exhausted all the other ones. The problem with legitimate interest is that you have to be very clear when you do what's called a legitimate interest assessment on the proportionality and necessity principles, okay, two really important principles. And I think we're going to struggle to get the necessity principle in that space. Again, we don't know the answer to that. We have to wait and see. If we look to Garant is the Italian Data Protection Authority. So they issued a desist processing order to OpenAI for ChatGPT. We may well remember that. The reasons that they did it, they were fourfold. There was an inadequate privacy policy. That's okay, if we think about that, practically every organization has an inadequate privacy policy. They're boilerplate, they're copied from others. They also didn't have appropriate age controls. Again, you wouldn't think that that would be big enough to issue a desist processing order, considering all that Meta has done, and they were never issued a desist processing order. But they didn't have a legal basis for the training data. And that's not fixable. The data's in there, the horse is bolted, the model has learned. Even if they did remove the data now, the model has still learned from it. So I don't think that's fixable, and I think the approach has been that it's better to seek forgiveness than to ask permission. I think that might have been the OpenAI decision at the time. And accuracy and hallucinations were a huge problem at the time. So OpenAI had to address a number of different issues, but it's still unable to address the legal basis issue. Where's that going to end? Nobody knows. But I think what's going to happen in this space is that we're going to have to say a legal basis is required, and for everything that's done already, we're just going to have have an acceptance that it's done. The horse is bolted on the ones that have already been trained. Inferential derived data. Now this is my favourite. As I said earlier, I do think that there's a monster here. This is Pandora's box. So there's a number of different words we use to describe inferential data. We call it derived data, inferential data, predictive data, profiling data. There's lots of different words we use to describe this kind of data. But it's not data that the data subject or the individual gave the organization. It's data that got created. So how do they know you have it? So we're just going to talk a little bit about the complications of that data and how there are so many inconsistencies before AI ever existed. So, or ever existed as in the AI Act ever existed. In 2022, the CJEU, the Court of Justice of the European Union, issued a ruling in a Lithuanian case which had nothing to do with data protection. It was an anti-corruption case, but they were asked to assess whether personal data that can indirectly reveal sexual orientation falls under protections for special category data in GDPR. Now, essentially what the case was about was, if my name is Mary and I'm married to Louise, and you're in a governmental office, the expectation is that you can infer my sexual orientation as it's a same-sex marriage. And therefore, you have to treat the data as special category data. There's additional obligations on you under special category data and an additional obligation for a legal basis for processing from Article 9. So the CJEU interpreted that the processing of personal data liable to disclose sexual orientation in this way constituted processing of special category data. So that's what the CJEU said. In the same year, Norway's DPA, their data protection authority, said that breaches, Grindr, breached the GDPR because somebody using Grindr inferentially indicates their sexual orientation. And all data in Grindr should therefore be treated as special category data. So they concurred really with what the CJEU had said. But then the Spanish Data Protection Authority came along in relation to the Grindr case and said, no, they disagreed with that. So we had inconsistency in this space. And I can understand the inconsistencies as well, because it is so complicated to decide whether it actually is special category data or not. This is only going to grow with AI, because AI has the capacity to pattern match in a way that we never could. So it's the pattern matching allows for the inferential data to grow. Let's take a look, because what I think about inferential data is there's so many incredible inferences that can be made, but there's also so many troubling inferences. And we don't want to stop the inferences being made that are so positive in our society. We want to be able to limit the troubling ones. So here's a list of some interesting ones. So Facebook, Meta, whatever you want to call it, sexual orientation is what they're able to infer your sexual orientation, race and political opinion. So these are very uncomfortable places. You don't want these things to be inferred. But they can also infer imminent suicide attempts. So it's a very important thing to be able to do, a powerful thing. Susceptibility to depression, also Instagram, X, are able to infer susceptibility to depression. The most interesting one, I think, is Microsoft, which undertook a study of mouse movements. So it looked at the mouse movements and tremors using the mouse movement and scrolling velocity. And it was able to detect early onset Parkinson's to such a degree that it matched the scientific early onset tests. And, so that's incredible. Scoring systems, we've been using scoring systems for years, so like Uber and eBay. And a really interesting one is judging citizens or organizations' behavior and trustworthiness. Now, AI Act says you're not allowed to do that because that's considered a prohibited activity. So you're not allowed to develop a system that does that. But of course, in China, they have the social credit scoring system. And in Europe, we would say, and I know the US would do too, that there's a level of discomfort with that. So we would consider that a troubling inference. But I teach a master's program in information security, privacy and ethics in Dublin City University. And in that university, we have a lot of Chinese students. And they consider this a beneficial inference, not a troubling. And that's why privacy sometimes is a wonderful subject, because there isn't a black and white in it. What might be troubling inference to some may not be a troubling inference to others. So it isn't black and white, and I think in this space we're going to see a huge set of challenges as we grow in our capacity to use AI. So back to the lovely data subject rights. The main vehicle that privacy laws provide, for addressing predictions is to provide individuals with the right of access and, of course, the right to correction. But it doesn't work for predictions because they pertain to events that have not yet occurred, accurate or inaccurate. And again, we don't know how this is going to look. We don't know how this is going to how we're going to manage this issue going forward. We have to wait on cases. I think that's really where we're going to get progress in this, is through cases. Transparency, a very difficult thing. Transparency is not a new issue. We've had privacy policies for years that have been so untransparent, they've been opaque. But transparency is definitely an issue when it comes to training data, and transparency is definitely an issue when it comes to algorithms. So anybody ever use Ticketmaster? Ticketmaster? Nobody knows how tickets are assigned using Ticketmaster. And pre-AI Act, I tried to find out using GDPR, but they could the only thing they could tell me is about my data. And that's all that's allowed. Under GDPR, I can only make a complaint about my data. Under the AI Act, anyone is allowed to complain about an AI system. It may not be related to their data, but they can complain, because there's a complaints authority, about an AI system. So, when they build that infrastructure, I'm going to be in the front of the queue with Ticketmaster to say, I want an explanation for how they process data. I want to know how seats get assigned. So it's going to be an interesting space. The transparency piece, because of the AI Act, applies not only to the data, but also to the algorithms and to the processing of the data. So it's a watch this space, because the argument that most organizations are going to do is trade secret, isn't it? That's where they're going to go, is trade secret. So this is a quote from Professor Daniel Solovey, if anybody knows him. I always say to my class, my students, if I show them a video of Professor Solovey, that nobody speaks when Daniel speaks. So I'm a bit of a girl fan. So to fully comprehend the decision-making processes of these algorithms, it's necessary to consider the collective data of all the individuals included in the algorithm's data set. But we can't provide that data to individuals without violating the privacy of all the people in the data set. So, our leading scholars think this is not an easy challenge to resolve. So we're not going to be able to resolve this challenge overnight ourselves. How to address the challenge? Again, it's explanation aware. The ICO says explanation aware is about all we've got in terms of the tools in our arsenal at the moment, is to improve those privacy policies, improve those privacy notices, and make them explanation aware. Accuracy is my second most favorite one, because it also includes truth. And truth, and we have seen this never before as we have in the last 6 months. Truth is so important. What is true and what isn't true? Truth is the fundamental that democracy is built on, to understand that our vote, for instance, is true, that our journalist is true. These are the pillars that democracy is built on. So it's very important to get this piece right, but we're not getting it right at the moment. So everybody know this test. I don't know, has anyone come across it before? It's called the Chihuahua Muffin Test. And for many years, AI couldn't get it right, okay? It wasn't able to detect which was a teddy and which was a Chihuahua and which was a muffin. But a human can, okay? We are a bit confused by it, but we can definitely make the selection. Now, AI can do that now. In 2020, it couldn't. So AI can do that now. I'm just going to go forward, just one into this one. But what the human is not able to do, and what the AI is able to do, is to spot a deep fake. Okay, so the AI can't spot the difference between the Chihuahua and the muffin, but we can. And we can't determine what is deep fake and what isn't, but they can. And this is an interesting space. There is no answer to it, but I'd just like to point out that I think this is going to be Pandora's box also. So does the World Economic Forum Global Risk Report, which says it's number 2, AI-generated misinformation and disinformation are one of the 5 risks that we believe are going to be a material crisis globally. And so it's watch this space. We know that we've seen, and this particular example has been used a number of times in sessions during the week, which was the chief financial officer, the deepfake CFO, insisting that the financial clerk wire 25 million, and they did what they were asked to do, of course, because they believed it was a real person. So what can we do in this space? So how to address the challenge? Well, there's a number of things, for instance, that the ICO would say that we need to do. One of them is we need to start doing DPIAs on everything, not just on what the GDPR says a DPIA should be done on. We also need to consider validity codes. In other words, that if I'm on a Zoom call and I'm the CFO, I need to have a validity code, which is a code that I communicate during the course of the conversation that allows you to know I'm not fake. So I think it's a new concept, these validity codes. It's like when we needed to be able to authenticate ourselves many years ago, we started using passwords. They became ineffective. We had multi-factor authentication. I think this is just an extension to that authentication mechanism. Then we have bias. So bias isn't specifically in GDPR. What's in GDPR is the principle of fairness rather than bias. Does anyone remember Tay? Tay? So Tay, 2017, Microsoft launched Tay in China. Tay spent a number of weeks in China learning from tweets in order to be a chatbot, really, and would become your friend. And Tay was sweet, Tay was kind, Tay was loving, Tay was just a really nice chatbot. And then they decided that they were going to launch it into the US, and they launched it in the US, and they had to pull it within 24 hours because, in the words of the reporter, it had gone to racist in 24 hours, less than a day. And so many people then started talking about the bias in the data, in the US data. And this is where I think the problem is that actually the data was biased in China. They just didn't see that it was biased in China. When the data is loud, then you see the bias. But when the data is quiet, you don't see the bias so easily. Chinese people operate under a panopticon. The effect of the panopticon, or should I say, they operate under the Great Firewall of China. They know it exists. They know they're being watched. They behave in a way that essentially is biased data. It's not real. It was quietly biased data. It moved over here, it became loudly biased data. They saw that the data was biased and they said, you know what, we need to fix this problem. But they should have known that it was biased over here, and they didn't, because it was quiet bias. And I think that this is a real problem, is quiet bias, the one that doesn't make noise, the one that isn't seen. If we think about diversity, and we think about men and women, I went to a conference recently where the keynote speaker was talking about trying to get an image generator, an AI image generator, to generate an image of a CEO that was female. And she went through a number of different tasks to try to get this to happen, even going as far as saying, I wanted to be the CEO of a tampon company, and it still was a male CEO. She could not get a male or a female CEO to be generated by the AI. And that's quiet bias, and that's the one I think that is the most dangerous bias. So what we did with the bias was we introduced anti-bias tools. And so we introduced these tools to unswing in a different direction, but we swung too much. So we ended up with images. This is Gemini, images from Gemini saying, here's a portrait of a founding father of America, here's an image of a Viking, here's the image of a pope. The one that I find most amusing in that is the image of a Viking. Being from Ireland, I know that the Vikings came and they brought red hair, fair skin, and blue eyes. So it's just interesting that that's the image of the Viking. So I think we're going to, unswing again, but that we need to get these anti-bias tools more effective. So what can we do in this space? Well, how to address the challenge. Number 6 there is the most interesting, is ethical frameworks. Finding an ethical framework is quite difficult right now, and there's one from the Omidyar network. It's called the Ethical OS. 8 key points. You basically take your development team and you say, let's talk about, is there a possibility for bad actors to use this in a way that we don't want it to be used? It's trying to anticipate risks that aren't so evident. It's trying to anticipate that quiet bias. So it goes through 8 particular different areas: disinformation, misinformation, inequality, and try to explore those through an ethical framework at development stage, so building it in early on. And then finally, responsibility for assessment. So what is that responsibility for assessment? We have a conformity assessment. It only has to be conducted on a high-risk system. But we also have a data protection impact assessment. So who's going to do it? So the difficulty is this, if we talk about the approach. This is the 4 bodies that are identified in the AI Act. So we have providers, importers, distributors, and deployers. They're the 4 bodies that are in the AI Act. In GDPR, we don't have these guys at all. In GDPR, we have data controllers and data processors, and there's zero alignment between them. So we can have a deployer that's a data controller, and we can have a deployer that's also a processor. We can have a provider that's a data controller and a provider that's a data processor, although they're likely to be data processors. And we have a joint relationship between deployers and providers, because somebody can create their own AI system and then they become a provider and a deployer. The lack of alignment between the 2 pieces of legislation means that the responsibilities of data controllers and the responsibilities of providers or deployers, and they call them deployers. They used to call them users. I don't know why they changed the term to deployers, but I'm guessing there's a reason. So I think that this is going to be a really, really complicated space as to who's supposed to do the conformity assessment. But it's going to be the provider that has to do the conformity assessment. But there's going to be organizations that are joint deployers and providers. So who's going to do the conformity assessment in that case? Again, it's watch this space. We need to have cases to be able to make interpretation. For anybody who does want to do the assessment, the conformity assessment, There is a free tool available from the University of Oxford. Luciano Floridi wrote a paper about it. You can just go to that free tool and you can do the assessment. But it's a really easy way to kind of walk yourself through your first conformity assessment if you have to do one. So that's it from me. I'd like to move to questions now. If anybody would like to ask a question, we have mics.
First off, I'm really impressed that you were able to keep going with all the noise. You're my new hero, because I would have thrown a temper tantrum and walked out. So, good job there.
Thank you.
The thing I really want to try to get at is, how are these rules going to work when things are changing so quickly in terms of the AI landscape? And if companies see these rules coming, it's difficult now for companies to kind of virtualize risk because somebody's doing it. But once you have kind of an AI responsible for it, how is the EU going to keep that responsibility from just like becoming just whisper air?
It's a great question. I mean, I think it's tantamount to impossible. The AI Act was the fastest piece of legislation ever produced by the EU. The amount of money that was put in and invested in it. But I don't think you can keep up that speed of response. I just don't think it's possible. And I think if you go back to, if you remember what I said, it doesn't get created in a vacuum. It's bad organizations. And I think what we have to rely on, and we had to do it with GDPR as well, we had to rely on organizations adhering to the spirit of the law, not just the letter of the law. And I think most organizations will do that. I think a lot of organizations are really, really good. But if we go back to what Eric Schultz said 15 years ago, Google likes to get right up to the creepy line, but it never crosses it, Other organizations are happy to go across that creepy line. And so I don't know that we're going to be able to keep up pace with that, but I think it's a great question.
Thank you very much for the presentation. A couple of questions. One is specifically on GDPR, and I think GDPR and CCPA, the California Act, they both give the customer the right to actually tell the company to forget them and not use their data for, it's not just the PII, but not use it for like analytics or anything of that nature. You did mention, and I think it came up yesterday in the crypto panel as well, that once the model has been trained, right, then it's very difficult to actually delete the data. So what are companies doing then? I mean, are they deliberately breaking the law then and saying, we won't be able to delete your data?
Yeah, absolutely. That's why organizations like OpenAI have been used as, and the example, if you don't fix this, we're going to shut you down. Just on the previous point, CCPA is similar to GDPR, but it doesn't have the same level of data subject rights. There's 2 specific rights in CCPA, so it has a limited number of data subject rights. But there's more rights in GDPR than there is in CCPA. That's the first part. Yeah, organizations are operating at the moment illegally, and that's why they can be shut down. But I think they're also, there's an acceptance that this was a problem that couldn't be fixed, so we didn't fix it. And so now we have a situation which is organizations bought into something inappropriately, but they didn't do it intentionally.
Okay. The second question I had was, there was talk about legal obligation to use AI. What if the company cannot actually run the operation effectively without using AI? Is that enough of a reason? Like, you saw a lot of presentations yesterday by cybersecurity companies saying, hey, we could not solve this problem before. Yeah. We can do it now. So if you don't use AI and you're back to like people chasing the problem, then there aren't enough resources, there isn't enough time. So we basically won't be able to protect the company or won't be able to protect the customer.
So that legal basis is called legitimate interest. Believe it or not, legal obligation means that, say for instance, if I wanted to launder, or not launder money, if I'm being told by the government that I must check your passport, then I have a legal obligation to process your passport because the government has told me that I must do that in order for you to set up a bank account. Know your customer legislation. So that's a legal obligation. That an organization can't operate its business without AI is a legitimate interest. That's the legal basis that you would use. But to do legitimate interest, you have to be able to stand over the proportionality and necessity principles.
Okay.
Does that
So,
answer?
yeah, it does. I do have another question, but I'll give some time to you.
I don't know who was.
Hi, thank you for the talk. My question is, my company's training models using data from both the US and the EU that is totally de-identified of any PII. And my question is we wouldn't even have a way to find, if someone requested the data to remove, we wouldn't even have a way to find whose data that is. So would that be okay? Is there something else we can do?
So is that the answer, is that, you know, if you've used the data, and a lot of, say, differential privacy would be another place where you'd see the data, keeping the value of it, but de-identifying it. If you've used the data, you have access to the data originally, but now you've stripped it. And if I want you to remove that data, the only place I can ask you to remove that data is in the value of what you've trained. But you can't undo that. It's not possible for you to undo that. So the answer is, I can't do it. But the legislation says in GDPR, you must. And so we're at a space where we're going to have a case. And when we get a case, the CJEU are going to have to make a decision on how that progresses. But you're absolutely right. You cannot deliver on that request at the moment. And there's no fix for that. But I think you can't turn around to say to organizations, now you're going to have to stop doing business. We can't do that.
Thank you.
I'm being reminded to let everybody know to make sure to put in the survey results.
Good afternoon. Thank you so much for this lecture. It was super informative. I used to work for a member of Congress, and I'm actually writing a research paper now about assessing risk, particularly about the AI Act, the 4 different tiers. There isn't really a test that I'm aware of to determine whether or not a software or like an AI program is very harmful. So therefore, why would anyone categorize their program as very harmful when it's quite restrictive? and please, if you know of any leads, I'm very interested.
No, and so it's harm in GDPR is done through the data subject. So we have 10 criteria that are elevating the risk to the data subject, and it's very straightforward from a GDPR perspective. On the systems within the AI Act, they're very specific. There's a series of recitals at the end that give you an exact list, 2 pages long, of the systems that are categorized as high risk. So I just gave a couple of examples there, but there's a whole list of them. So you don't get to determine if it's high risk or not. The AI Act tells you whether it is or it isn't. But outside of the AI Act, so in the US, you don't have that. So how do we translate that into a set of criteria for you? Really, that's I don't know.
In practice, yeah.
Yeah, I don't know the answer to that.
Well, yeah. Thank you so much.
Thank you. Thank you very much. Thank you.